So this is what I don't understand, and maybe somebody can help it. And maybe it was just me. Maybe I was a different prosecutor. I did not indict any cases if I didn't have discovery. I didn't indict a case without an autopsy. I didn't indict a case unless I had ballistics, because at the end of the day, if you end up having somebody who the whole thing is they fired a weapon and then ballistics show that they didn't fire a weapon, somebody else did, that person has been taken into custody. They got to make bond. Maybe they got to hire an attorney. People had better start viewing people as people, and that when people indict cases and they don't have discovery, then it's like a year for us to get, well, not for us, for the defense to get discovery. Then we're just sitting around here. From March, we've been waiting for DNA and ballistics. And somebody indicted this case and didn't have DNA and ballistics.
Carvajal did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
It's true.
Violating condition number 4 in Bexar County, Texas, the defendant Josue Carvajal did then and there fail to report to the supervision officer as directed for the months of September and October 2025 in violation of condition number 4.
How do you plead to that?
True.
Finally, violated condition number 29 in Bexar County, Texas, the defendant Josue Carvajal did then and there failed to submit to drug testing as directed by the court officer, supervision officer for the months of September and October 2025 in violation of number 29.
True.
State will waive the remaining.
Any objection to the waivers? Did you understand by pleading true to those violations, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 2, 2, 2, 4, and 29?
Yes, ma'am.
Court will find violations 2, 2, 2, 4, and 29 true. Is there a proposed agreement?
There's not, Judge. The state is asking that you grant its motion, enter an adjudication of guilt, and sentence to 2 years in the prison. Judge, this is Mr. Carvajal's 4th MTR. If there's anything that's shown based upon the record in the court's file, it's that we find ourselves in a situation where Mr. Carvajal is either pleading true to a condition 4 or 2. The court then allows alter an amendment to his conditions, and we're back in the same position. I don't believe Mr. Carvajal wants to be on probation any longer based on his lack of complying with the conditions, probably despite what he's going to tell the court today. But I don't think he's a good candidate. He's shown he's not a good candidate, and I think it's time that he's revoked.
All right, defense, what are you requesting?
Judge, he pled true in his accepting responsibility. This is not new violence, new victims, or escalating. He's struggling with instability and structure, I think. Is whether those violations is sufficient, is necessary. What can we do to address those? He failed probation. He stopped engaging. He has accepted responsibility, and the court has extended opportunities. But I think we got to look at there's been no violence, no weapons. There's no more victims. There's no assaultive conduct. There's no dealing or trafficking. There's no other criminal behavior besides just not showing up. He does have multiple negative drug tests. He completed the Bexar County outpatient program, additional outpatient participation from 2024 to 25. I think he's done over half of the community service hours. He has some prior employment compliance and, like I said, some community service. I think that what we have here is a cognitive issue. I think he would like to be extended and do some sort of inpatient for the cognitive. I think that would be graduated response through the MTRs. I think that'd be appropriate. It's not so much that he was using, but he's just missing. So again, I think it's more cognitive than anything. I think he needs some sort of stability. He needs structure and something to help him with his fear and avoidance with probation. I don't think he's minimized anything, and I think the maximum sentence would be reserved for somebody who, I don't know, has done something way worse than what's going on here. So if you do decide to revoke, we would ask for 6 months, Judge. But we would ask that you continue, and that he can come out a better person. He's still young, and I think we can still save him. Do you want to say anything to the court?
Judge, I know I have been.
Oh, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
So I got about.
Why don't you report?
I just have been. I've been honestly unresponsible over my actions.
Here's the thing, and so I want you to tell me whatever you want to tell me, but I wanted you to know where I'm coming from so you can understand the answers that I'm looking for from you. You've been in this court previously before. It's always a violation of condition number 4 or condition number 2. And then I will ask you, what do you need from the court so that you will complete this probation? And whatever you need, I always give it to you. So I've given you the MRT. Each time you come in, I try to help you with something. And we're back here for the same thing. So you can address those issues, because that's the issue. You keep coming back for the same thing.
The MRT, I did the class that I was actually attending, it was.
That's not the question. The question is, why aren't you reporting and why aren't you giving drug tests? That was the question. So she wants to know the answer to that. Why aren't you doing that? Or is it how old are you?
22.
And so you're old enough to get to court. Why haven't you grown up and done that? Why aren't you going?
Then I'm responsible.
What do you say?
So do you have a vehicle?
I did not. I actually lost it in a car crash.
That's your problem, right? It's your responsibility to get there. And you're doing a GED in jail right now?
Yes, I am.
So like, why did you do a GED when you were not in jail?
I was actually attending to it, but there was a 6 months program and it wasn't.
Let me ask you this. Did you sign up for a GED program when you were out of custody?
I was trying to, yes. Ma'am.
So the answer to that is no. Okay. Why?
There was a 6 months waiting program, and between that, my probation officer wasn't letting me attend to it. She wanted me to attend right on dot, basically, like on time when my probation was about to be due. And I kept on telling her there's the time, it's not gonna add up. So I tried, but I tried actually even going I tried to attend a different GED class, but they wouldn't let me because I had already did it 3 times.
Okay.
Is there anything else? Why do you think you should be continued and not be sent to prison? Why this time? Whose fault is it that you're here?
Take full responsibility over it.
All right, any questions?
Mr. Carvajal, you realize you're not in charge of the timeline here, correct?
Sure.
And you realize that the court determines your conditions of probation, correct? And you fail to comply with those, right? So why should the court believe this time as you're trying to take accountability that it's going to be different than any other?
I'm sorry, you have to answer the question.
Feel like I'll do better now this time, even though I know that I have messed up previously.
All right, the court is going to grant the motion, find you guilty. The court will hear argument on time. And I know you're saying you want 6 months, counsel,
Yeah, ma'am.
and state you're asking for 2?
Yes.
All right. All right, the court is, as previously stated, the court is going to revoke, find you guilty, and the court will sentence you. And I'm going to give you credit for things that you have done. The court will sentence you to 13 months in the state jail facility, give you credit for any time served. Court will request the therapeutic community. And there is to be no contact with Hitzel, Hitzel, and JAR, JAIR, or ORTIZ. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. Do you understand? All right, and counsel, do you think he needs therapeutic community or something while he's there?
I think there's some cognitive issues, Judge,
Mhm.
if we can get that addressed.
Okay. I will, with the therapeutic community, you're going to have to sign up for it. It's going to be placed in the judgment, and then you'll have to sign up to it as well.
That's good.
All right.
You need to get that.
Okay. All right. Thank you.
Thank
Good luck to you. Okay.
Yes, ma'am.
So,
All right. Anyone else here who's ready? Yes.
And you have to speak this word. Or do you, I don't know if you want to do the one on Zoom first.
Yeah, we're going to do Anders.
Anders?
Probation, this is an application. Court is calling 2026 CR 005042, State versus Gary Anders. Can I have parties announced for the record for the state?
State.
Defense?
Robert Porter.
And are you Mr. Anders?
Yes, Your Honor.
Counsel, you received all discovery. Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Anders, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
I did, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, I believe we're waiving the punishment enhancement, but otherwise proceeding this.
Any objections?
No objection.
This is an opposed offer. Okay. All right, Mr. Anders, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with unlawful possession of a firearm by a felon. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he is currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Anders, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
I am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand? Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison, $2,000 fine. State is opposed to your applications. Did you understand that to be the plea?
I believe so, Your Honor.
All right, so you can apply for probation. They're going to tell me that they don't want you to have probation. And I could deny your application and sentence you up to 6 years in the prison. Did you understand that?
Yes, Your Honor.
All right, state defense, is that the plea?
Yes. It is, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, are there been any such motions?
Yeah.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Thank you.
State any evidence.
Judge, we have to say exhibit number 1 and all attachments.
No objection.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to jury trial, the right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent. Did you understand the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
I did, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you would like to come back sooner.
I'm ready today.
Okay. All right, the court then will hear argument.
What was there for vote, Judge?
Judge, I understand it's a felon in possession of a firearm. And I hope the court read that police report, but I hope she read it very carefully. Okay. The simple fact of the matter is he pled guilty because he is guilty. That's what he said. He should have never had a gun. His son's birthday, he's 18 years old, went to his stepfather's house. Stepfather, for some reason, doesn't like him, but he went over to the house just to say happy birthday to his son. Because the stepfather doesn't like him, calls the police and tells the story about how he is threatening him and pointing a gun at him, which never happened. And what ended up happening, the police show up, sees him out there. Oh, we did there, and there's a gun found in the vehicle. Then the father-in-law turns around and tells the police, oh yeah, he never threatened me, and he never brandished a gun. The reason I tell that story, Judge, is this. He should have never had a firearm because he is a felon. This isn't the kind of case that we give up to 6 years. He's not brandishing it. He wasn't threatening anybody. It was just about him going to see his son on his birthday. Shouldn't have never had the gun, and his stepfather just not liking him, trying to get him in trouble. So we're asking this court basically to grant this application. If not, based on the facts of this case, Judge, I would hope that the court would go on the lower end of that sentence.
Hey,
Judge, our argument is that Mr. Andrews was sentenced to 2 years TDC back in 2019. He was then sentenced to 4 years TDC back in 2024, and he was found with an unholstered firearm in his waistband. Judge, we'd argue that Mr. Andrews is not complying with the law. He's already had multiple penitentiary trips, and we think 6 years is appropriate.
all right, I'm gonna give you your choice. These are your choices. You only have these 2 choices. There are no other choices.
Okay.
1, I'll deny the motion, sentence you to 2 years in the prison. Or 2, I'll grant your application for deferred adjudication. However, if you're revoked on the deferred adjudication by some other judge, because I will not be here, you're looking at potentially 10 years in the prison.
Okay, what?
The deferred adjudication.
Can I have one quick second?
Sure.
We can docket.
The docket. Oh, you mean, yes. Excuse me, Norma,
Different,
can I have a, copy of the docket
different.
for the court reporter? Oh, this is. Okay, thank you. And while they're printing it out, before I even take it up, I'll make sure I give you something so you'll have it. Yes. So what does he want to do?
I'll take the deferred.
All right. Court will sentence you to 4 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, 100 hours of community service restitution, hours. Once you complete parenting, the community service hours will be deemed satisfied. There's to be no contact with Ivan, Ivan Hesbrook, Hessbrook, or but the easiest way to get in those sober living homes is through felony drug court, through lifetime recovery.
I think there's no like numbers or anything. I think,
Probation will help you.
okay, that's what I was asking.
All right. So did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And Ms. Abrams, even though he has priors and he's not allowed to own a weapon, I'll just add no possession of firearms or ammunition.
Yes, Judge.
All right, good luck to you.
Thank you
Thank
very
you.
much.
You're
Have a
welcome.
good day. Judge.
You too? Sure.
You're almost.
Who's next?
We have Hillard Smith, an MTR.
All right, Norman, let's see if we can get the box cleared out.
Yeah, I'm trying to guess that's somebody that's in jail.
All right, 2020 CR 5441. What page?
He is on page 9, 3 down. Where's your attorney?
Taureese Hillard Smith. Can I have parties announced for the record for the state?
Lauren Espinoza for the state.
Roger Bettis for Tyrese Hilliard Smith, Your Honor.
And are you Mr. Hilliard Smith?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Tyrese James Hilliard Smith who was placed on deferred adjudication in 2020 CR 5441 for the offense of assault peace officer judge on September 2nd, 2021 for a period of 5 years? Is that you?
Yes, Your Honor.
State?
Violated condition number 4 in Bexar County, Texas. The defendant, Taureese James Hilliard Smith, did then and there fail to report to the supervision officer as directed on 9/5/25, 9/26/25, 10/25/25, 11/25/25, and 1/28/26 in violation of condition number 4.
Did you say 10/29/25?
Yes, sir.
Okay. To that, how do you plead? True or not true?
True, but there's some clarification.
State will waive the remaining.
Any objections to the waivers?
No.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, I understand.
Knowing that, do you still wish to plead true to violation of condition number 4? All right, the court will find violation of condition number 4 true. State, what are you requesting?
Judge, we are requesting that you grant state's motion, enter an adjudication of guilt, sentence to 2 years in TIC cause number 2026 PF 19606.
And what are you requesting?
Judge, that's our general agreement. We just, he was on a special mental caseload. So he was to report twice a month. So there were some months that he reported once, and then there were some months that he reported twice. There was some occasion he wasn't able logistically to make it on the particular date, but he would report. Again, that's critically the most important violation that he's done. And the new offense was failure to ID, and there was some miscommunication regarding whether he said that his birthday was at 1997 or 87. But that's fundamentally why we're here.
So what is probation? What are you recommending on this?
Mr. Hilliard Smith was on a specialized he's on the mental health caseload. He was doing very poorly. He was supposed to be reporting 3 times a month. That I just got off the phone with the manager. That's what he stated. There were several instances where he just was not reporting. He wasn't, with the mental health caseload, if you have to make your appointments with your treatment providers, and he wasn't doing that. On the court summary, what's listed is for state ISF cognitive track followed by ISP. However, I would like to also point out the other concerns that they have listed. It just says that Mr. Hilliard Smith continues to demonstrate criminal thinking behaviors. He does not appear to be severely impacted by a MH diagnosis, and most of his legal and family financial issues could improve with the use of new cognitive restructuring, new values, and moral reasoning.
Okay. So the mental health issue is not, according to them, the reason for these violations.
That's right, Judge.
All right. So you're in agreement with the 2 years?
We are, yes.
Mr. Smith, are you waiving your right to appeal?
What does that necessarily mean?
That means that if I follow this agreement, the 2 years, that I'm not going to give you permission to appeal this sentence. So that means the 2 years will be the 2 years.
I think he did want to make a statement, Your Honor. I'm not. He would like to say something, Your Honor.
Sure. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
James Hilliard Smith.
All right, what would you like to say?
First and foremost, I would like to apologize for being irresponsible. Could have used my time more wisely. Secondly, just speaking in general, just want to take my son to the park again, stuff like that. But I understand I made the wrong choices and decisions and put myself in these circumstances.
He just apologized for his action, Your Honor.
All right, so do you want to accept the 2 years? Because this is what I'm telling you. They've agreed, your counsel and you and the state have agreed to 2 years. Probation is saying, keep you in custody, send you to ISF. Now, if you remain in custody for transfer to ISF, I don't know what the wait time is, but you'll be in custody. And if you have another motion to revoke, who knows, the state may not agree to 2 years. They may be asking for the full 20. I'm not going to be here. Someone else will be here. So, are you waiving your right to appeal?
Yes.
All right. The court will grant the motion, sentence you to 2 years in the prison, give you credit for any time served. And the court will recommend the therapeutic community and take in consideration 2026 PF 19606. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I understand.
All right, because because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. Good luck to you, sir.
Thank you. Likewise.
Oh, thank you. All right. Anyone else in the box?
Yes, ma'am, I still have, Timothy Soto. Oh, wait, it's, yeah, he's in jail. Timothy Soto.
No, it's not.
You said I'm on?
Is your name Timothy Soto? Yeah.
Oh, Venegas? There's page 5 at the bottom.
Venegas?
Very good.
Yes.
Right.
What is happening with this case?
This is gonna be a probation drug court referral, and if he's refused, he's going to ICF, I believe. If you wanna put us in.
Hello, how's it going?
There's two cases, one's 2/2, one's gonna be a JSAT of 98. I'm pretty sure they're evading, they're gonna reduce it to a misdemeanor.
Oh, the evading is going to be reduced?
Yes, sir.
Okay.
JSAT.
Yes.
All right, the court is calling 2026 CR 004818 and 2026 CR 004816, State versus Luis Venegas Jr. Can I have parties announced?
Charles Gold from Mr. Venegas.
And are you Mr. Venegas? Counsel, in each cause number, have you received all discovery and did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. All right, I have two applications.
I should have done the other one, Judge. It was my fault.
That's okay.
The misdemeanor.
All right, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
And each cause number, did you review the true bill of indictments with your attorney? Did you understand it?
Yes.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State, in the possession case, are you proceeding on the indictment as presented?
No, your Honor, state moves to waive the punishment enhancement.
No objections, we proceeded then.
And in 1-6, are you proceeding on the indictment as presented?
No, your Honor, state will proceed on the lesser included offense of the class A misdemeanor evading arrest or detention.
No objection to that, we proceed today as well.
And each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
And the cause number ending in 1-8, you're charged with possession less than 1 gram, penalty group 1. Range of punishment is up to up to 2 years in the state jail facility, with the lower end being 180 days at the state jail facility and up to $10,000 fine. And the cause number ending in 1-6 for the evading arrest as a class A misdemeanor, the range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. In each of these pleas, if you have an agreement with the state, the court does not have to follow your plea. If the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
Yes, ma'am.
Counsel, has your client been able to provide any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Venegas, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney in each of these cause numbers, and did you understand it?
Yes, Your Honor.
According to the plea in 1-8, punishment is to be assessed at 2 years in the state jail facility, $600 fine. State recommends community supervision. This will run concurrently with 2026 CR 004816. State will take into consideration 2026 AL 004165. There's to be restitution of $120 to the lab for testing. Outside the agreement, the state is recommending 2 years community supervision, TAP evaluation, 100 hours of community service restitution, the MRT, random UAs, referral to felony drug court. If not accepted, then ISF. In the cause number ending in 1-6, the state is asking, or you agree to Class A misdemeanor, evading arrest detention, 90 days in the Bexar County Jail, $600 fine, no applications, concurrent with 2026 CR 004818. Did you understand those to be your pleas?
Yes, ma'am.
State defense?
Yes, sir.
Did
Yes,
you
ma'am.
review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sure.
Any such motions?
No, Your Honor.
Then to the Class A misdemeanor, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
To the drug case, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
Yes, Your Honor, seal for State's Exhibit 1 and all consent of both clauses.
No objections.
All right, State, do you have the dismissal for me to sign, the AL number?
I turned that in.
No, I'll check and see.
I'm pretty sure it's in the paperwork, Judge. She did give it to me and I'm pretty sure I turned it in.
All right, I'll look and see.
Hope it is.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Your Honor.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulations of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty in each cause, and the court will find you guilty. Off the record, clerk, do you have that dismissal? I don't see it anywhere.
Don't open my sign. I don't know if it's in between the.
All right, I'll I'll go through each one to see. All right, and cause number ending in 1-8.
Found it.
5%.
That's okay.
Sorry.
I'm sorry.
That's what my.
That's okay. The court will sentence you to 2 years in the state jail facility, suspended and probated for 2 years. There's to be regular reporting by Zoom or in person. Regular UAs, proof of employment within 45 days of release, no employment as a home health care provider or with minors, $600 fine, probated. In custody, there should be a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, follow TAP recommendations. Field visits, 1 time per month for 4 months. This is run concurrent with 2026 CR 004816. Take in consideration 2026 AL 004165. there's to be restitution of $120 to Bear County Laboratories for testing. 200 hours of community service restitution. Do you have any children?
I do.
What are their ages?
I have 6-year-old, 5-year-old, 2 biological that 8 months. She's gonna be 9 months, August 12th. And my son, he's gonna be 2 years on July 11th.
All right. How far did you go in school?
I only completed 8th grade, but I made it to 9th. I didn't complete it.
All right. So when's the last time you had employment and what were you doing?
I was working for some general contractors that I met off of Facebook Market.
Mhm.
I also did landscaping for myself. I work for Bear Concrete also.
Okay.
I have potential job with Toyota. I know a person there that could get me in as long as I'm clean, you know.
Mhm.
So I have that. But pretty much I think I'm gonna get in contact with the general contractor again because he works for Fire Station 8. And he's a really good person. He works at the firehouse and things are local. So he's always had work for me. He does general contracting on the side also. I'm not sure exactly what's gonna end up happening work wise, but I'm not really too worried about it. I'm gonna try to get a night job when the opportunity comes, just so I could take care of my responsibilities throughout the day.
Okay. All right. This is what the court is going to do. As previously stated, 2 years in the state jail facility, suspended and probated for 2 years, regular reporting by Zoom or in person, regular UAs, proof of employment within 45 days of release from custody, no employment as a home health care provider with minors, $600 probated, in custody the following: a referral to felony drug court. If not accepted in a felony drug court, then a TAP evaluation, follow whatever conditions recommended by TAP. Field visits 1 time per month for 4 months, concurrent with 2026 CR 004816, taking consideration 2026 AL 004165, restitution of $120 to Bear County Crime Lab for testing, 200 hours of community service restitution, 100 hours to be deducted upon completion of parenting classes. The remaining 100 hours, you either do sober support meetings. For every sober support meeting you complete, an hour will be deducted. Or if you complete a trade school, the remaining 100 hours will be deemed satisfied. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
I'm looking forward to the drug court. I hope I'm able to qualify.
Oh, you have a great attorney here. He's going to get you in.
I hope so.
And Judge, just, I don't know if that's part of the agreement. If he doesn't get accepted, it was ISF, but I know you said TAP, but I just, okay, just, I didn't know.
That's outside the agreement.
Okay, that's fine. It was just.
All right. All right. And then, and the cause number ending in 16 on the Class A misdemeanor of evading. Court is going to sentence you to 90 days in the Bear County Jail, give you credit for any time served. There's a $600 fine, time and money to run concurrently. This is to run concurrent with 2026 CR 004818. Is this considered a judgment satisfied?
Yes, sir.
All right, and the court will show that the judgment is satisfied. In each of those cause numbers, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it
Yes, sir.
and sign it?
Yes, sir.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All All right, so here's the thing, and we're off the record. You're always supposed to want to maintain your sobriety for yourself, but if you're at that point where you're like, I really don't care about myself, do it for your children, okay? All right, good luck to you. You're welcome.
God bless.
God bless you too. As soon as
But they're just one of her.
I'm sorry, who?
David Martinez. The jail.
David Martinez. Probation, this is no application.
Thank you, Judge.
And what page is David Martinez on?
It's on, page 7, 3 down.
Yes. Find one that writes.
Thank you.
It writes? Yeah. Okay, thank you. Court is calling 2026 CR 005-825 State versus David Martinez. Could I have parties announce?
State.
Valentina Kogur on behalf of Mr. Martinez.
Are you Mr. Martinez?
Yes, yes, Judge.
Counsel, have you received all discovery? Did you review it with your client?
I have, and I did.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I do, Judge.
Counsel, do you waive the reading?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Sure. Mr. Martinez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with evading arrest detention with a previous conviction. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is and he was.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
yes, Your Honor.
According to the plea, punishment is to be assessed at 113 days in the Bexar County Jail under 1244. Did you understand that to be your plea?
Yes, Your Honor.
Defense state.
Yes.
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed. Oh, Cindy's out for a moment, but
Okay.
who did you say on page 5?
On page 5, 2 down, just Wilson. Jamie Wilson.
Jamie Wilson or Jaime Wilson? Who's his attorney?
It's Jonathan, who should be on Zoom, Judge. The plea paper, did you look at the plea paper? It's Wilson. I think that.
No, I mean, who's his attorney?
Right here. Jonathan Alvarado.
Oh, well, we're waiting for
Okay, well,
Cindy to come back. So,
I have Jesse Abreu.
oh, just have a seat. I'm sorry. Just have a seat for a moment.
We already did.
What page is that on?
Page 3 down. This one right here, that's the thing.
Oh, I can't do any pleas because Cindy's not here. Yeah, she took a break. So anybody here who has something that does not require a court reporter?
Yes. I think.
All right. So, well, he raised his hand first, then I'll take you up.
The judge, he's bigger than me. I'll let him go first.
Oh, look at us. I love this. All right, Tim Molina, who do you have?
Shiati Wilson.
Chiatique Wilson.
And Judge, he's in the back, but this is just a discovery matter, and I can talk to him once they bring him out, but we can handle this part of it.
Just one second.
So, it's on the discovery hearing today. The SAPD turned in like a 1.4 terabyte drive. I actually went over the lunch break to 2 stores and failed to find one. So I'm going to order one off Amazon and I'll bring it to the state on Tuesday because I'll get it this weekend. There's also some labs missing. And so I was just going to ask if we could have another reset for another discovery.
So the labs were missing. What labs are missing?
I'm assuming firearms type labs.
Like GSR, DNA, ballistics. So I tried to call and have like a voicemail with their current lab. I just haven't heard that.
Okay, so here's my question. Is this an allegation that alleges that somebody was maybe shot?
Yes.
Yes.
Okay, so this is what I don't understand, and maybe somebody can help it. And maybe it was just me, maybe I was a different prosecutor. I did not indict any cases if I didn't have discovery. I didn't indict a case without an autopsy. I didn't indict a case unless I had ballistics, because at the end of the day, if you end up having somebody who the whole thing is they fired a weapon and then ballistics show that they didn't fire a weapon, somebody else did, that person has been taken into custody. They got to make bond. Maybe they got to hire an attorney. People had better start viewing people as people, and that when people indict cases and they don't have discovery, then it's like a year for us to get, well, not for us, for the defense to get discovery. Then we're just sitting around here. From March, we've been waiting for DNA and ballistics. And somebody indicted this case and didn't have DNA and ballistics. Because if they had it, then that means the state has it now. And they should just be able to give them that paperwork. That's one of my pet peeves. And since we're talking about pet peeves, my other pet peeves, because I used to be a defense attorney, making defense attorneys pay for drives to give the state drives to get discovery when they should be getting that without doing that. If I were defense attorneys, I would start putting that in as my fee and putting it down. This is what I paid for these drives and I need a refund.
Well, I do keep the receipts, Your Honor.
Thank you. Norma, this is the last discovery and y'all need to be prepared to tender an offer. And if you don't have this discovery by then, the court will entertain whatever motions you wish to present. Recall this for 45 days for discovery.
Yeah. July 6th.
All right, July 6th, y'all need to have everything and y'all need to walk over to whomever has these ballistics reports. If it's the San Antonio Police Department or the sheriff's, may I have the ballistics report? If you have any type of addiction issues, you need to take care of that, because otherwise only one or two things going to happen. You're going to get arrested for another offense, or somebody may end up having to identify your body. Okay. All right. Good luck to you. What page is Alicia on? Oh, I found it.
That's a good one too.
All right. Mickey Aguilera, who do you have?
Monique Riley Williams,
All right. What place is Williams on?
page 1, number 2.
Page 4.
Oh,
Oh, page 4.
and when I saw she was number 2 on a
All right. What's happening with this case?
Judge Ross.
She needs to come up.
I think the last time she was in front of you, she was wearing yellow.
Oh, yes. All right. Does she also have a motion to revoke?
That has been continued. Year and a half or 2 ago.
All right. Who's the prosecutor on this?
I was dealing with Megan this morning, Jay.
All right. So where are you on discovery?
We are not. While asking for an offer this morning, Megan has tossed an at-large case
Mhm.
I have no discovery on. Apparently it's around the same time frame as these 2 charges.
Okay.
And Megan needed time to reach out to all the victims, alleged victims.
All right, Norma, can you recall this in 45 days for discovery?
Yes, on July 6th.
All right, we'll be back on July 6th. Once you sign the reset form, you're excused. Are you here on July 6th?
I think I can, yeah.
All right, thank you.
Thank you.
Judge,
Yes,
Also wanted you to know, after reviewing her file, she's doing well on probation.
Okay, awesome. Keep up the good work on probation.
Can I hear that again, Judge, doing well?
What, you want to put that on the record?
Can we make the court reporter put that down, like she's doing well?
All right, thank you.
Mommy.
You indicted this case without DNA or ballistics? The judge suddenly exploded during a discovery hearing, slamming prosecutors for moving forward on a shooting case before critical evidence was even finished. The courtroom got tense fast when defense attorneys revealed they still didn't have key ballistics reports, DNA results, or other major discovery evidence months after the indictment. That's when the judge went off. He blasted the idea of charging someone before having complete evidence, warning that people's lives are destroyed when courts rush serious cases without knowing who actually fired the weapon. The judge angrily pointed out that someone could spend months in jail, pay for lawyers, and fight criminal charges, only for later evidence to prove someone else committed the crime. Then came the harshest moment of all. People better start viewing people as people. The judge called it one of his biggest pet peeves and even criticized the system for forcing defense attorneys to pay for giant hard drives just to receive evidence from prosecutors. The courtroom went completely silent as the judge ordered prosecutors to personally track down the missing reports before the next hearing. Do you think prosecutors should be allowed to indict cases before all evidence is ready? I'm curious.